everybody. We're here today with a special guest, Kathy from InDieZone podcast. She has a beautiful podcast, and all of her links from Spotify, Apple, Amazon. There are, it's called Intune, Lead Notes, and her YouTube channel are all down in the subscription. And we're going to get some help today to figure out, what does this all really mean? Welcome, Kathy. I'm so happy you were able to join us today.
Me too, Audrey. It's so good to talk to you again. How are you?
I'm doing fantastic. How are you?
I'm doing very well. I mean, we were expecting this order possibly to come down today. It's been a very, very long journey for the defense in this matter, and it's quite the order, all 20 pages of it. So excited to talk to you about it and hear from your subscribers if they have any questions and thoughts as well, because we're seeing already the misinformation as to what this order says floating out there in the cyberspace. Hopefully we can clear up a few of those, Audrey, because that's what we're here for.
That would be great. Oh, let me just say hello to Anna. Truth and Justice True Crime with Anna is here. Thank you for coming. Hello. All right, Kathy, let's get started. I'm excited to see how does this work?
Okay, well, as we know, Audrey, because I know you've been following the case very, very closely for quite a long time. So you know that when the state of Idaho alleged that this motion for change of venue was filed in July, that was absolutely incorrect. And literally over the weekend, the episode that talked about that, because they also claimed that they had not received the data from the defense and were going into this hearing on the 29th without it. Then they had to come back a few days later with, egg on their face. And they had to say, oh, yeah, you know what? We did get that. We want to make sure going into the hearing. And I'm like, well, maybe if you had an expert, if you hired an expert who could interpret what you had in front of you, you'd know that you received the information. And then they also, it was two hits. I mean, then they alleged the hearing or the motion was in July, like this, the defense is trying to delay things. Absolutely not. And I see, Audrey, you have the original motion right here as referred to in the first line by Judge's order today. Very good.
Wow. Yeah. We're prepared around here.
You always are prepared. So here we see, what is this? Okay, we see that this was electronically filed up on the upper right-hand corner. This was filed on January 30th, 2024, 4:22 p.m. What is this? This is when it was filed, when it hits the docket. And Julie Fry, as we know, is the clerk of court. It's her responsibility to maintain all of the court records in a certain way. You just can't have it like in my office where I just throw things. I got 10 boxes over here. They got to be in a certain way for retrieval purposes. And she has a series of deputy clerks. So you'll see Ms. Reeves as one of them. So she is actually physically doing the work, and she works under the direction of Ms. Fry. So you'll see that on the upper right-hand corner. And now if you look on the left-hand side, you're going to see the side that's filing it. You're either going to see the state's attorneys on that side, or you're going to see us here, the defense's attorney. And this was back when Ann Taylor was with the Kootenai County Public Defender's Office that this was originally filed. And if we go down just a little bit, we have the other two attorneys that are assigned to the case. Eliza Mazoff, who we saw at the hearing on the 29th, and also, although he didn't speak, he was there as well, Jay. So, I didn't see. Did you hear him speak at all? I was trying to, go back on my notes. I don't recall. I was even unsure if he was even there.
I don't think he's been there.
Mm-hmm.
Hopefully, we get to see more of him. But yeah,
I thought he's argued quite a few interesting motions. He's certainly written quite a few of them, but here we see, as we go down there, in every one of the filings, we're going to see, this is called the style of the case. This is in the district court. This will tell you what court we're in. We are in state court in Idaho, the 2nd Judicial District, which is Latah County included in this district. That's the case number. It has to be on every filing. Motion for change of venue. What is a motion? It's an application for a court order. And what you see typically, you see the moving party. Here we have Mr. Kohberger. He's filing the motion. Moving party. You'll get a response from the other side, and then there'll be a reply. And then that should be it. Those are the three main things that you get. You get the motion. This person's looking for judge to sign an order. And then the other side will either, we have no objection. Sometimes that's happened, very rarely in this case. Usually they oppose it, as they've done here. And then a reply brief comes now. And we see here Mr. Kohberger is for the first time moving the court for a change of that. He's actually moving the court for the entry of an order for change of venue. And by this motion, he requests. Now, notice how they humanize him. They don't call him Mr. Kohberger here as they usually do. I thought this was a really interesting tactic that the defense did here. Brian requests a jury pool from outside of Latah County. Now, when I saw this, Audrey, and I think we talked about this, I said, holy smokes, are they looking to bring in a jury pool from outside Latah County into the Moscow? Because that's what you agree. That's sort of like it was a little confusing here to read, right? So
that's how it's written, right?
Right. It's a little bit ambiguous here. I mean, she says you're changing venue, but then in the next one, they want a jury pool from outside Latah. But then we learned later on what they really wanted. This motion is made pursuant, and this is where they give legal authority. You just can't go into a court and say, you know what, I don't like this courthouse. You don't have any good cokes, and there's no food that I can get. The parking stinks. You got to give legal authority and cite to it. So here he is she always cites to, even though this is a state case, the U.S. Constitution takes precedent over everything. And that's just written in. You'll find that in Article 3. We all remember from government class. That's the supremacy clause, meaning that even though Idaho has its own state constitution, if these rules or anything is in conflict with the U.S. law, U.S. is going to win. So you'll see 5th, 6th is the big one. The two ones that he really, really references a lot are the 6th and the 14th Amendment. 6th Amendment has all of you have a right to an attorney. You have the jury in criminal proceedings, jury that is impartial toward you. This isn't a kangaroo type court where they're all ready before you even come in. Not guilty. You look guilty. You look like you're guilty. You're shifty eyed. I don't like you coming in. You're wearing too much gel in your hair. I don't like you. No, got to be impartial jury. And then the 14th Amendment, that's where we see the due process clause. And that tells us, and there was quite a bit of fireworks we're going to get into a little bit later on when Judge was accused of violating Mr. Kohberger's due process privileges. And that means you're entitled to notice before the court hears something. You're entitled to an opportunity to be heard, to give your side of the story, and you must have a disinterested jurist. You can't have a judge who's predisposed against you. Those are the three big issues that come up in due process when your life, your liberty, or your property is at issue. Then they go he then cites the Idaho state constitution, the Idaho rules. We see this over and over again. And then that's a statute I see, 1801. At SEC means it's 1801. It might be 1802, 3, 4, 5. There's more portions of it.
Oh, that's great. I never would have known that. This is
that's what
great.
we're here for. We're going over government. We're going over government from high school. Okay, so here we go. Bang, bang, right here. 6th Amendment argument. A fair and impartial jury cannot be found in Latah County, owing to the extensive inflammatory pretrial publicity. Allegations made about Mr. Kohberger to the public by media that will be inadmissible at trial. Okay, what is this? She's really pointing out an important point here. People sometimes, and I think we heard from one of the experts that said, they may be making dinner, or you might be, just doing some chores, and you've got the television on, or you've got YouTube, and you're hearing something that's inflammatory, like Brian Kohberger was stalking the victims. You might hear that, might hear it once, twice, 3 times, 4 times. Then you're picked for trial, and you don't know if you heard that in courtroom or if it was out of courtroom. Inadmissible stuff, things like that are going to be inadmissible because it was made outside of the proceedings, outside of the courtroom. So that's why and then the small size of the community, the salacious nature of the alleged crimes. These crimes were horrible. They were as atrocious as they come, and the severity of the charges, including DP. The state has said they're seeking the DP on this one. enlarging the jury pool will do nothing. It will not do anything to overcome this pervasive prejudicial publicity. Do you recall when this case was set for trial in October of 2023 before Mr. Kohberger waived speedy? And Judge said, no worries, because they were concerned that there would not be enough of a jury pool. A lot of people would get struck. Well, Judge says, no worries. We're going to send out an extraordinary amount of notices for jury. He got one. Yes. He had to say that. Remember that? He had to disclose that he got one. That's how small and interconnected this jury pool is. I wonder, I'm saying, geez, I wonder if Dr. Edelman called, Judge's house, being that he's
right?
He's in the jury pool, right? But okay, prejudicial. I don't know about you, Audrey, but I have yet to see a book about Mr. Kohberger or a documentary on a big. I'm not talking about, like, they want to keep hitting, and I get very upset with Judge. That's one of the things I don't like about this order is he talks about the armchair sleuths and the YouTube. Listen, the people that have YouTube channels, maybe have a couple hundred, thousands, maybe some of the larger ones may have 10,000s. They don't have a Nancy Grace following with millions of people that are hit with one time. She's going to hit millions of people. Same thing with any of the Dateline. I have yet to see one documentary about this case which focuses on he is innocent until proven guilty in a court of law, that talks about such things like this dog that we just learned about, apparently, that he trains, that talks about the things that he did. I've yet to see one. It's all about he did it, and he did it. So that's where the prejudicial publicity. Latah County does not have a large enough population center to avoid this bias. Further, the size of the community and the interconnectedness of the citizenry. This was big. This was a big issue that a couple of the experts talked about. It's not just that it's a small jury panel where you have maybe 20,000, 22,000, possibly at 23,000 registered voters. You have to exclude the people under 18, the people who have convicted felonies and can't vote, the people who don't vote for religious purposes. So you're now down to 20,000 people, 22,000, but then they're interconnected. They know someone that works for the Moscow Police Department, or maybe worked at the university, or they go to the university, so it's this interconnectedness of the citizenry. If this was New York, or LA, where there's, 8 or 10 million people, there wouldn't be this interconnectedness. So these were some big problems that she is now telling the judge. And when you see the judge saying, I've gone over this for many, many months, this is the first time he's being hit in the face with this. Now, she doesn't have the expert opinions to back it up, but she's just basically giving him a snapshot of what will come, because she brought experts in to hit every one of these points.
Mm-hmm. Yes.
So she goes on here. She ends, Mr. Kohberger requests an opportunity to be heard. Due process, remember we say the 14th Amendment notice opportunity to be heard, impartial judiciary through evidentiary presentation. So this is where we know that she's going to have expert witnesses coming in and either producing declarations, affidavits, or coming into court and giving live testimony, which we've seen all three in this case. An argument no sooner than the end of April 2024, dated 30th of January 2024. Any comments, questions, or anything you wanted to? I know I just kind of went through it so quickly, but anything, Audrey, that you wanted to?
That was great. I just want to say hello and welcome to Heather Fitzgerald. Hello.
That's right, Heather. Felons can vote as long as you're not currently incarcerated. Okay, anything else that we wanted to talk about here regarding? So we see here clearly that this motion for change of venue was filed January 30th, 2024. The order that came down, this was the motion that as we said before, a motion is an application for a court order, and we had the court order come down today, which is what, the 9th of September, but it's granting this motion right here.
Excellent. Excellent. So now we have a jumping off point.
Yeah.
This is where it started for this.
So Audrey, once the state of Idaho received this motion, did they say, not opposed. We agree, Judge Chan, or did they oppose it, or do you remember what happened in response to this in February? I think it was like February.
Oh, yeah, there was a response opposing it. I have that. Let me bring that up.
Yeah, because they had, a couple of options. They could have not responded at all, or they could have agreed, or they could have just, there we go, Audrey on top of things as per usual. And we see here again, deputy clerk in charge of this file is Ms. Reeves. As you mentioned, she's been very busy the past couple days with all of these filings, right, Audrey?
Right.
Okay, so we see here on the 8th of February 2024, we see the state coming back, and we know this is the state's motion for a couple of reasons. Number one, we see the prosecuting attorney's name in the upper left-hand corner. Ingrid Beatty, who did a big part, she played a big role in this change of venue and opposing it. She's not Latah County. She was granted the right to come into Latah and to help to prosecute. She had to apply for that, and there's a motion that was filed and Judge granted. There's one other person, I think Jeff Nye is the other, that came in to help at no cost. They're not charging Latah County anything, which last year somebody filed, I think it was one of the media outlets, filed a motion to find out how much this case was costing. And so, do you remember that, Audrey? I think it was maybe last summer, 2023. It might have been one of the Idaho statesmen, one of them, they filed a public records request. So Julie Fry gets it. She sends it up to Judge, not concerned. She doesn't want to violate the non-dissemination order. And so Judge, what he did is he disclosed the amount that the defense is being paid. But I said, well, what about Bill Thompson? Is he doing this for free? I mean, it didn't disclose what Bill Thompson's pro rata expenditures are in this case, right? He's getting, benefits and everything else. So I thought that was kind of interesting that he didn't disclose that. But in any event, we see here, as you very correctly stated, Audrey, the state objected to the defendant's motion to change venue and requested a scheduling order. Boy, oh boy, they have been hot on getting this scheduling order, haven't they? So what's this all about, Audrey? We go down just a little bit. Okay, here we got, now we have their appearance comes now, state of Idaho, and objects to the defendant's motion to change venue as it is premature. This is the same argument they gave. Remember when they were trying to strike the grand jury indictment, and they came back and said, this is premature. You don't even have the materials from the grand jury yet, Mr. and Ms. defense attorneys. It's premature. The state requests that this court set a trial date. Boy, oh boy, he has just been so hot on getting a trial date. A briefing schedule for the defendant's motion, a hearing date for the motion to be heard, and a deadline for supporting memoranda, affidavits, and witness disclosure sufficiently in advance of hearing so that the parties can adequately prepare. Okay, so I mean, this is a viable request. He wants deadlines to be put in place, but he's wanting, first thing he says here, he's using this response as an opportunity to ask for the scheduling order, which he has been asking for since for quite some time, certainly since the IGG information was released in late December. They started asking for the scheduling order beginning in January. So first thing out of his mouth, we want the trial date. And then that sets everything. Then you get all the pre-trial leading up to the trial dates. And they go, defendant's motion to change venue is premature without sufficient basis. So he's saying, and it's true. I mean, you've got to have that supporting expert witness testimony to go out there and to do exactly what Dr. Edelman did, which was to do his surveys. Defendant has not provided the court with adequate information to conclude that a Latah County jury could not fairly and impartially decide. Again, here's the Sixth Amendment counter argument. No Sixth Amendment violation here, Judge. They have not. They do have the burden of proof, Audrey. They're the moving party. You need to persuade the judge that what you're asking for, this order, is proper, not the state. Just like it's not Mr. Kohberger's duty to have to prove himself innocent. It is the state's burden to prove him beyond a reasonable doubt as to each and every element of each count that he's charged with. So here we say, okay, no adequate information here, Judge, to conclude that a Latah County jury could not fairly and impartially decide the defendant's case. In Idaho, a motion for change of venue is within the discretion. This is 1,000% correct. It was Judge could have easily denied this motion. There's some things where a court does not have discretion over, like if you show something, the elements or whatever it is you're asking for, A, B, and C, and you show that A, B, and C is present, judge has to grant whatever it is you're asking for. Discretion, he's got some latitude. He could have easily looked at Edelman's stuff where they said, hey, Ada County, and sometimes Ada County's knowledge of this case, it surpassed Laptop County. He could have used that as grounds to say, hey, denied. But he's citing here Idaho case law standing for the correct proposition that the motion for change of venue is within the discretion of the trial court. And then he goes into the factors that the appellate courts in Idaho look for. And they just keep bringing up testimony of jurors voir dire, it being able to possibly be the means to ferret out anyone who responded to, remember Dr. Edelman's responses in the reply? Oh, if he's found not guilty, then this is going to happen, right? Those people, the state saying could be weeded out. And I think that absolutely not. It would have been chaos at that trial if we're starting out day one, June 2nd, 2024, in voir dire and going through these who knows how many people, and then you're excused, you're excused, you're excused, you're excused. Other factors are whether a defendant challenged for cause any individual jurors, the nature of the pretrial publicity. So they're going to go ahead and they're going to produce evidence that will talk to some of these factors here. Say here, because publicity is not a standalone reason. It's just because you have a lot of publicity, that in and of itself is not sufficient to change venue. You need to show either presumed prejudice or actual prejudice within the jury pool. And do you know what they show? Judge in today's order, he did not agree with the defense that there was actual prejudice that was shown. He found presumed prejudice, and we'll talk about that when we go into the order. Page 15, he makes that finding. So publicity, there could have been 1,000,001 stories about Mr. Kohberger. It's not enough. You can't just show that. You have to show that the jury pool is just tainted so badly that it will violate his Sixth Amendment privileges if he's not allowed to move this trial somewhere else. Okay,
right.
Look at it again. He said, and the state respectfully asked to set a trial date, set a hearing for. Okay, so we see he's basically repeating himself here, and we have Mr. Thompson and Ms. Beatty both signing this. And you notice that he said he might have even said it 3 times. I wasn't looking that closely.
Yeah. Now, the moment everybody's been waiting for, here is the order.
Here it is. So this was a long time in coming. Okay, January 30th, and finally, so she won a big battle, and her team. They won a big battle here. It was, Audrey, I know that you are the DNA expert around here, and you're doing such a fabulous job going over DNA and explaining it. I don't know. I keep going back and forth. What was more hotly contested? Was it the IgG DNA evidence and getting it turned over in discovery? Was it change of venue? It's like those two are neck and neck. I can't think of anything else but those two that would even come close to being as hotly contested as this change of venue motion was, and the IgG information. The thing for Judge, at least with the IgG information, as he said in his October 25th very long order, that it was a case of first impression, meaning there was no case law to provide him with any guidance. Here, there's not. There's a lot of case law that provides him with guidance that we're going to go into here. But here it is. We see here. Now, this was rendered. That means it was the time it was filed, September 6th, 2024, 1655. So what would that be, Audrey? Like almost 5 o'clock in the afternoon or evening? And, when this thing was filed, it's pretty late in the day. And there was a lot of rumors that were floating around over the weekend about what this order said or didn't say, but it didn't hit the docket until today. Today is when we finally, and we're recording this on the 9th of September. But again, here we see, now we have the deputy clerk. Now we have another deputy clerk who's filing this. This is Beth Moffitt. And this is the order granting the defendant's motion to change a venue. So the motion that we saw January 30th was the application for this order. And now we go into, the judge breaks it down. And he says here under Roman numeral, big letters, introduction, bam, January 30th, 2024. Defendant Brian C. Kohberger filed a motion for change of venue. Now, a lot of people say, why do you keep harping on this? Because I've had a few conversations today. Why do you keep harping on this, that it was January 30th and not July 22nd? I said, because the defense has been unfairly told that they have been dragging their feet with things. They've not. We see how long they've wanted it, and they came right out of the gate and did not, and said we're going to oppose it. So this was not. Now, this could have been all taken care of if the state would have looked at the situation here, case law, because unlike IGG, there was plenty of case law here. They live right there in Moscow. They know what's going on. They could have said, you know what, in an abundance of caution, we will agree to a change of venue. And all of that we saw this year leading up to this order would have been obviated. There would have been no need for it. So we saw a lot of judicial time, a lot of energy, and a lot of resources to finally get this order today. And so we see here that Brian Kohberger filed a motion for change of venue. And here we see the legal authority, both state and federal. February 8th, as Audrey, on top of things as she always is, said here that on February 8th, the state filed an objection. An objection. Hi, Excited Utterance. How you doing down under, joining us right now?
Hello and welcome, Excited Utterance.
So good to see
Good
her.
to see you.
So as Audrey just put up, literally waived his extradition. What happened? Are these fools talking about? He is striking. That's right, Heather. That's right, Heather.
You're so right.
I know. We would like some answers here. We never get it. Okay, so it says here the hearing on Kohberger's motion was originally scheduled for June 27, 2024. Okay. Now, those people that do follow the InDieZone podcast, and I hope that you do, because I try really hard to kind of give this information 3.5 to 5 minutes maximum information on everything that's been on the docket, dating back to Audrey's favorite document, the affidavit of probable cause. That's episode 18,
Yeah.
right? 1 to 18, and we have literally gone down the pike. Now, June 27th, two things actually happened on that day, Audrey, and I know you know both of them. One is that the trial order was entered that day and signed by Judge, giving all of the pretrial deadlines and dates leading up to June 2nd, 2025 trial date, which is what Mr. Thompson has been asking for and asking for and asking for. The other thing that happened on June 27th, 2024 is that the parties, and that is Mr. Kohberger and the state, went to Judge and said, Judge, we have this hearing that's already scheduled for June 27th, 2024. We would like this moved to August 29th, 2024. Was this because the defense was trying, Audrey, to drag their feet again, because we've heard some complaints. That are against the United States Constitution, that don't feel the Sixth Amendment, the First Amendment, and all of these amendments mean anything. No, absolutely not. The reason why this hearing had to be reset from June 27, 2024 is because of what happened on March 22nd, 2024. That is when Judge entered an order putting a stop to Dr. Edelman's survey. Remember, Audrey, early, that was a Friday afternoon. Here comes Bill Thompson. He files the motion. Judge, we have reason to believe the defense, I'm paraphrasing, the defense has violated the gag. Oh, I can't call it a gag order. Judge gets very upset when we call it the gag order. It's the amended non-dissemination order. They said, because they are going out, they're conducting surveys, and we've just found out about it, we need to have them stopped because they're tainting the jury pool. They're violating your order, Judge. And so Ann Taylor very quickly filed a response, and then Judge that same afternoon, the 22nd, bam, you will not, no contact with any jurors or potential jurors pending hearing. And he doesn't even set a hearing that afternoon. So then a couple of days later, that was Friday, Tuesday, it was the 26th, then we had Kohberger file his motion to set aside that it was basically a restraining order. It was an injunction or a restraining order because it violated Mr. Kohberger's due process privileges. Remember, notice, opportunity to be heard. He wasn't given a hearing, and there wasn't even a hearing scheduled. Wow, Judge, that was one of the times that you saw he was really mad when they talked about that in open court.
That was the biggest fireworks of the whole case. It was just,
right.
It was very intense during those days. Oh my gosh.
And I think, young lady, you have done a very good job in terms of the PowerPoint, the infamous, this directly led to the Dr. Brian Edelman's second appearance at hearing. There was a hearing that was finally scheduled. It was like 2 weeks after this injunction. It was the first time that the court goes in. Edelman's appearing via Zoom. She gets up, she tries to talk, and he gets up and he's pounding his fist on the table and stuff like that. They reset the hearing. Next hearing, here comes Dr. Brian Edelman. He's got his PowerPoint with him, right?
Oh, yeah.
What happened when, I remember he was like, he didn't want that PowerPoint. Audrey, why didn't he want that PowerPoint?
It took so long. He's like, we don't need to see the PowerPoint. No. We don't even know what's on there. Yes, he knew. He knew what was on there.
Oh, and then it was sort of like the mic drop point.
Yeah.
He should, okay, Dr. Edelman, where did you find it? Was Darius C. Thompson, December 30th, 2022, when they're announcing Kohberger's arrest. There's going to be this pristine document with 0 errors in it called the Affidavit of Probable Cause, right? That's going to be released. We want you to disseminate it to everybody, press, right? And it was like, I think Judge is then realizing, hey, wait a second here. Okay. Well, anyway, long story short, all of that, the judge then decided, he entered an order. He didn't find that they violated the non-dissemination order and allowed the surveys to continue. But the problem now is they screwed up the schedule. They needed more time. So that's why the hearing was moved. So if anyone out there tries to say that the defense dragged their feet, no. This hearing could have been June 27th. They needed additional time for Dr. Edelman to complete his survey and then put together his declaration, which was extremely long. So also on the 27th, then we see the scheduling order that said when the witness lists needed to be disclosed in the documents, and that's what happened on July 22nd. So we see there that Judge is granting this. Now he's got to go back, and he's giving a little bit of background information. He says, okay, Audrey, one quick point, because I think this is what lost it. This is what many of us, you, myself, and a lot of other people included, were like, okay, where's the state's counter expert? Usually with this type of stuff, you have expert, you got counter expert. The counter expert in the field that Dr. Edelman, social psychologist, or Dr. Amani or Mr. Murphy would be in that field coming back and say, oh no, Mr. Murphy doesn't know what he's talking about. This is the correct interpretation. It's the battle of the experts. The state did not call any witnesses. I think that is what lost this for them. I think there's a possibility that if they would have had a couple of, good expert witnesses, that they could have won this argument, right? Yeah. There was some room to kind of say, oh, no, you can do this during voir dire. Look at Dr. Edelman. Look at his, his graphs where he's kind of going up and showing Ada County. They had more recognition about this case than Latah County did it. And Edelman saying, well, it's a larger population. But still, we don't know that. The state did not call any witnesses. The court has spent many months. And I think he has. I think he really spent a lot of time carefully considering everything about this. And then based on the totality of the factors, defendant's motion for change of venues granted. That's it. But with a twist, right? Which we will find out a little bit later on.
Yeah. Well, let me just say hello to a few people. I saw hello, Typically Unique, and hello, Cassidy Kane. Welcome. All right. So,
can we? What I wish Judge would have thrown in here would be, not only were there no expert witnesses called for the change of venue hearing, but let's go back to the CSLI. We had Syray, we had this one, we had Becca Barlow, they have not, I think that the defense maybe has 8 to 10 experts, and they're all good. Every one of them they bring to the table credentials. you know? And I mean, I still don't understand. I mean, Audrey, what do you think? Why would they not hire a single expert? You know, not one.
My mind goes immediately to, I don't think Bill Thompson is used to this because his style is very much with the plea deals. And I think he's been in his position for so long. He has some seniority. And I don't know how far that's taken him, where he thought, you know, I'll be able to do this. Like, and he argues all of the expert opinions
without qualification. You're right. I mean, he's an attorney, you know, so you argue, you make the legal argument. But I mean, you're not a biochemist, you know, you're not a social scientist, you know, these are very specialized fields.
And Ann Taylor has gotten the top of her fields. You're right. They're very specialized, and maybe he could be, I think it would be very difficult for him to find these qualified people, but not just qualified, but the top, like Ann Taylor has.
But I mean, not one. I mean, I think, I don't know if it was because, like you said, he's just not used to it. He's used to a plea deal. He's in over his head. But that's where you know, he's got two attorney general assistants that are helping him here. Didn't they say to him, didn't they think that they would need an expert? You know, I mean, they got the big picture over all of Idaho and all of the other, you know, DP cases where certainly experts were introduced. So I was very surprised when I saw that not one expert disclosure was made here.
Yeah.
On something as technical as this, you're getting into some real technical stuff. You're getting into human behavior, how the mind works. And, you know, it's not something that, you know, if you're trained to go to law school and you went to law school at the University of Idaho, wherever you went, you know, you're going to be able to do that. But they go into the background here now. He always does this when he gets into his long orders. And he says, as law enforcement investigated, news stations, newspapers, social media were flooded with stories and with speculation about the homicides. No argument there. That's true. Throughout the course of the investigation, the MPD, in partnership with the University of Idaho, the Latah County, what are they doing in here? You know, what I want to know is, why are they at the table? You know, to reassure the public and answer questions. I didn't see that this first time around for some reason. Who's not mentioned here is Latah County Sheriff. I'm very shocked why Latah County Sheriff has not been involved at all in this case. You know, so it's Moscow Police Department, Latah County Prosecutor's Office, Idaho State Police held press conferences to answer questions and reassure the public. And appropriately, the information released was limited to protect the integrity of the ongoing investigation. I got to take issue with Judge's statement here, because we have seen so many other cases, high-profile cases, where the police will release something to the public to reassure the public. Like, I was thinking about this today as I read this, and one of my biggest question marks about this case is, okay, we know from the affidavit of probable cause that there's supposedly an eyewitness statement about the supposed suspect. And they're supposedly having all of this video of the car, you know, making the 3-point turn at King and Queen, and, you know, going around and around, and, you know, from over in Pullman, and then coming back, and then going up to Indiantown and past Lewiston. They never released a photo of the car. Not once. Not once. In every case, you look at next time there's an APB, like they did. Remember when they did their APB back in, when was it? The end of November to the police, and then early December, they put in 2 stand-ins, 2 cars. And I said, are there 2 cars? Does one have a sunroof and one doesn't have a sunroof? Because we've all seen Brian Kohberger's car. He does not have a sunroof on his vehicle, nor is it a 2011 to a 13. So I always was very suspect that they never released a car, but then you know, just to basically say, people stay away. We don't want you going near this car. And also, what about the witness account? You know, why didn't they call in? You know, when these artists, sometimes they can pull stuff out of people, like what color was the hair? Was it male or female? Were the eyes close together? How bushy were the eyebrows? and they come up with stuff once person directly, like, holy moly, that's like, it's a pretty good rendition. They didn't do that. They didn't release an artist rendition to warn the public to stay away. Didn't release a photo of the car. So I think that, that it's just from the beginning, this has been a super secret case, too much. And then when things are not released, like we were saying before, 51 gigabytes, there's not a picture of a tree in any of that video that you could have released in good faith to the public, or a document that you could read all 51 gigabytes, and then the other 17 supplemental discovery requests and responses, they all are under seal. That, and I blame, in my podcast, I blame them both. Defense is just as guilty of wanting things under seal. And I can understand that Mr. Kohberger, does have the Sixth Amendment privilege, but the public has a right to know as well. And I think they took it to an extreme in this case, to where we're almost 2 years in, Audrey. And what do we know about this case? What's the evidence that they have?
Right. It just, I've never seen anything like it. I don't have any words for the way they're treating it. That's
a good way to put it, because I know that you're interested in true crime. I have been interested in true crime over the years, and I have never seen a case where they have, and it's until you look at the docket that you realize this is like Mount Everest of documents that are under seal in this case. And then they come out with these stories that signed by both sides. Oh, well, we need to have these documents under seal, which means the public will not see it, because if it's released, it could lead a danger, or it could put people, and it's individuals, plural, life in jeopardy. Okay, I looked at that. There was a recent stipulation signed to by the defense saying that, and then you also have the assistant state attorney. So I could see the defense saying that, because maybe they're saying the real people are on the loose. But why is the state attorney signing that? Whose life is in danger if documents are finally released to the public, if Mr. Kohberger is the sole and the correct defendant? He's not getting day trips out of Laptop County Jail, from what we know, Audrey, right? He can't make phone calls without being closely monitored. Whose life's in danger?
Right. I think they just copy and paste that. It doesn't seem like it's sufficient. Yeah.
So appropriately, the information released was limited to protecting integrity. I had to just go off on that. Thompson's life.
You didn't even laugh, Heather. It's probably right.
Yeah. So here we go.
Right.
Kind of reminding everybody, Kohberger was arrested and charged with 4 counts after the affidavit of probable cause was filed on the 29th. That led to Thompson swearing out of the complaint based on the affidavit of probable cause, presenting it to Judge Megan E. Marshall, who then entered the order of probable cause and the arrest warrant with 0 bond. And then the next morning, December 30th, 2022, he's arrested, charged, and again, media outlets descended upon Moscow, et cetera, et cetera. And then he's reminding, okay, same day, governing conduct. Yeah, that was. And then I think on the next page, he talks about the fact that the non-dissemination order was first entered. Both sides agreed to it. That was a stipulation that was signed by Ann Taylor, and I don't know if it was I believe it was Thompson who signed it. And they submitted it to Megan E. Marshall, who entered in the first non-dissemination order. So in an additional effort to protect Kohberger's right to a fair trial on November 7th. Now, this is something that kind of, I have to take issue with the defense on this one. I don't like what they did here. The court entered an order removing cameras from the courtroom. Now, the defense is who wanted 0 cameras at all in the courtroom. And I understand that they were concerned because Judge was very clear, do not focus on Mr. Kohberger. And they just kept doing it. They focused on his hands. They focused, to kind of say, oh, let's take a look at his hands and all this other stuff. So they really pushed the thing. But imagine, if there were no cameras in the courtroom and they would have gotten that order entered, we wouldn't have seen that hearing on the 29th. And I think that we needed to see that hearing. We needed to see the testimony. We needed to see Brett Payne up on the stand. We wouldn't have seen that. We wouldn't have seen everyone else, all of the arguments. So I think the judge was right. He did. He streamed via the court's YouTube channel, because he could have just basically said, listen, okay, you don't want to listen to me? Okay, here's the result, which in theory allows the public access to the proceedings. So that's one point that the public did win, while minimizing prejudicial photographs and video, focusing solely on Kohberger and his every move. That's what they were doing. You had the people from the media that used the fixed camera, and that's what they were doing. Now he's saying now, despite the efforts by the parties and the court to protect the jury pool from being inundated with information that is potentially prejudicial and false, excessive media coverage by mainstream media sources such as newspapers, radio stations, and television news outlets has continued throughout the state and nationally. Very true. And now this is and then he's saying, and perhaps more challenging is the ongoing spread of prejudicial misinformation, rumors, and patently false theories of the case on social media. And then here's where he starts hitting the Facebook, podcast, and blogs. Now, I gotta take issue with you, Judge. Two reasons here. All due respect, under the First Amendment, I'm going to give my opinion here, as we do under the First Amendment. Just number one, the fact that this case has been so secret from day one led to this breeding ground of misinformation, wild theories, and everything else. There has been a theory that will not die that Mr. Kohberger stalked one of the victims. And even though Mr. Thompson stood up in open court during one of the matters having to do with whether or not the non-dissemination order had been violated, he stood up. Remember, Roger, he stood up and said, that there's no evidence that he ever stalked anybody. That's at least 4 or 5 months ago, and people are still saying that's so. I think number one, what caused this to happen is the fact that so much is hidden about this case. It's not until you look at the documents that you realize just how much has been under seal and for how long it's been under seal and the reasons that they give. And secondly, it's not the podcasters, Judge, I'm sorry, and it's not people on Facebook and the blogs. It is mainstream media. It's not the little people, the independent people that might have a few 100,000, couple thousand followers, maybe 20,000. It's the people like Nancy Grace that have multi-million followers and has been doing this for 20, 30 years. She's got a following. It's the Dateline and this and the person who wrote the book, purporting to know what was going on in Kohberger's mind, and it got the New York Times. That's the problem, not the little one. So I was a little concerned that it seems as though, this is where the problem comes from. There have been numerous television shows and documentaries. I like how he puts that in quotes. Judge making a little funny here. Produced about the homicides and at least one book. What book do you think he's talking about here, Audrey? Any guesses? There's been a couple of books that have been published, but the one that was recently published, I think that'll, where they're purporting to know what's in Mr. Kohberger's mind, what's in his father's mind. And, I haven't seen one book yet that talks about first, his Sixth Amendment privileges that drive home the fact that he is innocent until proven guilty in a court of law or pleads guilty. We haven't seen any of the good things that he's done in his life. It's all this negative stuff, that's been out there. And some argues that venue must be changed from laptop to a location with a larger population that is geographically distant. Yes, Judge, not Nez Perce, geographically distant. I don't care if they got in the courthouse. Don't care that it's convenient for Mr. Thompson. He can drive back and forth, or yourself, with all due respect. It's got to be geographically distant from where the homicides occurred. The state asserts that a larger jury pool, extensive jury questionnaires, and voir dire are sufficient remedies that will make result in a fair. No, this is ridiculous. No, that's absolutely, with all due respect. I think that she did a great job getting up there and she argued the law, but the fact pattern does not apply to the law at that 829 hearing. What do you think, Audrey? You think he made the right decision here? Do you think that they just have to move one county over? They just have to move.
Absolutely not. I looked up the location of the Nez Perce courthouse, and there is a University of Idaho campus right across the street.
Really? Oh, I didn't know that.
Yeah, and it's also in Judge's district. So Judge is the administrative judge over that one too. So it wouldn't have been a sufficient decision because it's too close to Latah County
I
in
think,
a
yeah,
lot of aspects. Yeah.
I think it's something like I looked it up one time. Excuse me. I think it's like 20 miles from Moscow um, to Lewiston, which is the county seat where the courthouse is. That is too close.
Yeah.
To me, that's like not moving it at all because I would imagine, especially, I mean, I didn't know there was an Idaho, U of I campus. It makes a lot of sense that there would be, but I would think that the people in Nez Perce also had a lot of fear when, I mean, these were horrendous crimes. I mean, it shocks, absolutely shocks the senses. And, always, in their memory of those four youngsters who, went to bed, they were in their house, and to have this happen and have their lives and taken and the way that it was. And now we heard it first, oh, they were all sleeping in their beds, and then later on it comes out that maybe they weren't, and even if they were conscious for just 5 seconds, how horrendous that had to be to have this happen. So I'm sure that people in the next county over, Audrey, were probably also scared out of their heads, out of their minds. Like, who would do this? What kind of a monster or monsters are
I'm
on?
not sure how the state university works in Idaho, but sometimes if there are satellite campuses, there might be only certain classes offered. So if you need to take a class, you might actually be taking classes at the 2 different locations, especially since they're very close. So you may have a lot of the repeat, the interconnectedness, I do believe, is still at that location as well.
That's an excellent point because, okay, so the main campus is in Moscow. That's where the big campus is, right? So even if they have a satellite campus, usually those satellite campuses you're not going to see the spread that you see in Moscow in Lewiston, right? It might just be a few courses that you take, and then you have to go over to Moscow for the rest of it. Who knows? They could have been on campus, like they could have been there for the football and all of the events that they were having that weekend. They could have been there. It's not that far of a drive. I certainly had to do that. I lived closer to a satellite campus when I went to college, but there were times that I had to get in the car and drive to the main campus. This was before a lot of things were online as they are now. But yeah, you got to, and sometimes you just want to physically be there because it's a different experience when you're in the room with the professor and you can develop that relationship versus over the internet. But
yeah, and I will say there is another location in Boise, but I don't know how far away that campus is to the Ada County Courthouse, but it's the distance away that I think that's okay. Like that, since Boise is so far away that even if the University of Idaho does have a satellite campus over in Boise as well, I don't think it has the same type of interconnectedness.
Good point. And that's what she said. That's what Angela said in her very first, motion. Well, the motion that's been granted is that she talked about the interconnectedness, right? But that's a really good point. I didn't know that there was a satellite there. So, oh boy, I hope that, it's not ultimately going to be Nez Perce because this could all be, everybody's, saying, okay, good. This is a win for the 6th Amendment and everything. Because I see this as a win for the 6th Amendment, to the Constitution, which our rights are so precious that, every decision that's made here, like to not release any of the evidence, that's the First Amendment taking another hit. And this is a precedent that will be cited to, in other cases. So I say that this is a 6th Amendment victory today, but if it's just going 20 miles over, and like you said, there's a campus there's a satellite, there's a presence. So we say here, the state, okay, other factors. Now the big issue is the 6th Amendment right to a fair and impartial jury. That's what's going to, be the most important issue. But there's other factors. The case law says you take into consideration for the convenience of the parties and the witnesses and in the interest of justice. The state disagrees that moving the trial would be in the interest of justice or convenience to the parties and the witnesses. That's what they argued at hearing. As noted above, at the change of venue hearing, and again, this was August 29th, Kohberger presented expert testimony from, and here's his lineup of experts as to this issue. James goes by the name of Todd Murphy, Dr. and I just call her Dr. Amani. Do you know how to pronounce her last name? Because I've really done such a terrible job. Dr. Amani, Dr. Brian Edelman, and Dr. Tahir, right?
Yeah. Yeah.
And then Kohberger submitted various exhibits, and for the court's review, the state did not call any witnesses or submit any evidence. Boy, oh boy, Judge, do you really have to throw salt in that wound? I mean, this is now the second time he's pointing this out, Audrey. The court will summarize the key takeaways from that. I have to say, a lot of times when you look at judges and their guidelines, sometimes the presentation of evidence can be very boring, especially when you get experts up there, and sometimes they talk and they talk and they talk and they talk, and the judge. I mean, I think Judge was really involved. He was listening to the experts. He was taking notes. You could just see from his body language that he wasn't tuned out at all. And he was really taking it all in, wanting to make the right decision. And he talks about Todd Murphy, president of TrueScope. And then you can kind of read, in terms of what TrueScope looks only at mainstream media sources such as newspapers and news stations. And if anybody wants to know what his background is, he submitted a curriculum vitae at the hearing. He talked about it. I mean, he's been involved in this line of business for decades. I think he said that he was actually born into it, like his father did this line.
Oh, he did. Right. Oh, American Princess, hello and welcome. Welcome to Fast for Fleas. I love that name. I also, Joanna T. I don't know if I said hi to you, but I wanted to bring this up before we got too far away from what we were just talking about, Kathy, that the Nez Perce County. I do remember I think you're right, American Princess. I do believe that Ann Taylor made a point, or these experts made a point to say that the TV stations are shared. A lot of them are shared as the same ones from Moscow. So Nez Perce is also saturated with the same type of presidential.
Right. So it's going to be the same. They're going to be getting their news from the same sources. Great point, American Princess. Yeah. Of the mainstream media coverage in Idaho of this case, 30% of that coverage, 36% of that coverage has been within Latah County. This would include media like Moscow Pullman Daily News, Lewiston Tribune, and the TV stations out of Spokane, Washington. Kohberger requests this case be moved to Ada County. Point blank. I mean, at the end of the hearing, I can still see her up there. Basically, Judge, here, take your pen. Granted, Ada County. I mean, she said it many, many times. And they gave reasons. They gave reasons why Ada County. It's the largest. It's got a large jury pool. They had the resources. They have had multiple high-profile cases that were moved there. The Dallow case was one that was mentioned, right? They don't have these types of cases. Higher volume of coverage in Latah coupled with a smaller pool of eligible jurors means people in Latah has twice as many chances to be exposed to this case versus those residing in Ada County. And that's a point that he pointed home, many times. And you see now he's citing to the evidence here, Exhibit C, attached to the memo. So he's quoting and he's citing to the evidence in support of the motion for change of venue. And there's no evidence that he can cite to from the response and opposition, because as Judge has said at least here 2 times, they produced no witnesses and they produced no exhibits. The counter, a big mistake. And then you kind of look at, from February, however, and then going on. Here's I think he was, because I watched most of them. It was so long. I watched and I think that Dr. Amani made a big impression on the judge. I watched his body language as she's the one who really drove home the point. It says here how publicity about a case can shape potential jurors' attitudes. And once that attitude is made, it just doesn't get changed. Like going to your point, Audrey, that you mentioned a while back, They've been exposed to the police chief, James Fry, who was the police chief and he was the police chief there for many, many years before. He's a person that is, going to be of high regard. And if he comes forward and says, we got the right guy, well, why should I dispute that? Same thing with the prosecutor at the press conference. He's like, we got the right guy. We want you to take a look at. We got all the evidence against him. When someone, like the prosecutor, like you said, Audrey, he has been voted. He's not appointed. He's voted 3 decades. That tells you that community has a heck of a lot of faith in him, right? So if he gets
Absolutely.
up, all right, it's like your dad or your mom. You're a little kid. Your dad or mom says something, you can believe them. You're gonna, until you get to be teenager. But I mean, when you're very young, you're going to believe when an authority figure who's supposedly an expert in the field, like when Dr. Amani, an expert in the field, we don't know her very well, but we've seen her testify. We've looked at her credentials. When she says something, you're going to be impressed with that. So they have just had it driven home. They got the right guy, and the police chief doing such things is like driving his U-Haul truck up to the crime scene. And
yeah, don't get me started on that one. Oh.
But I mean, on top of that, what really didn't get talked about is the people in Moscow and Latah County saw James Fry driving through the streets with stuff that got taken out of the house. They saw those mattresses that got pulled out, remember, thrown in the back of that U-Haul truck? Driving through, they saw, and I think that the experts talked about this, that one person, she worked at the school and she saw the house from where she lived. People walked past it. They knew people. You don't have these problems in Ada County. You just don't. So I think that she really did, and then after Kohberger's, right? And we would have a University of Idaho president, Scott Green, getting into it, stating Publicity University community once again felt safe because Mr. Kohber, the boogeyman, had been arrested. And quite frankly, very suspect date of December 30th, 2022. This would be just days before everybody was due to return to the campus, right? Right? You're off for Christmas and the New Year's break, usually from maybe December 10th or 15th, all the way through maybe the 2nd, 3rd of January. Then people are starting to report back. Boy, oh boy, that timing was sure great to be in time for everybody to feel safe. I mean, could be just a big coincidence. Speaking,
very odd. Yeah.
Quite a few coincidences in this case. I think you've pointed that out, Audrey, that the statute of limitations for coincidences in this case, we think has expired, right?
Oh, yeah.
Generally speaking, individuals are more likely to trust and believe authority figures. So these statements by the Latah County authority figures are particularly impactful to Latah. They wouldn't be in Ada because they don't have that same. They don't see James Fry at the Labor Day cookout, and they don't see Scott Green when they go and walking down the hall if they're taking classes. They do in Latah.
That reminds me, Anne was doing her closing arguments at the change of venue hearing, and she mentioned the jazz festival. And I can only imagine if that was directed right at Bill Thompson, that he would be there with his band and he could see potential jurors.
Yes, with his covers band, right? His covers band with that Prophet 5 synthesizer, but let's not go down that road. Okay,
that's another time. Okay,
another discussion. Okay, then when they go into Latah County, small close-knit community members feel a sense of loyalty, right, to the views and felon. It's going to be, imagine Judge tonight going into the Moscow Walmart for some ice cream, or for picking up a few groceries. Some of the people there might not be very happy with him. What do you mean? We're not, we're biased, Judge. We're biased. All this, now let's talk about dollars and cents. There's a lot of money that's going to come into whatever venue has this trial, because people are going to, the restaurants are going to need to eat. They're going to need gasoline. They're going to need lodging, food, maybe entertainment, go out and see a movie at night or something like that. Ain't coming into Moscow anymore, right? So, yeah, but I think she made a really good point here. She said, a juror may feel an inner clash or conflict if they felt the state had not proven Kohberger's guilty beyond a reasonable doubt, because they may feel voting not guilty would cause community outrage or, once again, fear within the community. Powerful point, especially when you look at, in the reply, some of the responses. Some of the responses to the Edelman survey, they were scary. Burn down the courthouse. Mob mentality. It was pretty scary. The inner clash may cause jurors to vote guilty, even when they believe there is reasonable doubt as to guilt. The inner clash may even be greater when personal connections with Latah County are considered, i.e., my neighbor who was a police officer may be upset with me if I don't vote guilty. This is the human condition. As much as we all, that's why Vore Dyer, yeah, I can do it on the, I can. And it may not be that it's not that they're lying. It's just that there's something deep that's operating within the person, this inner clash, like she talked about here, that I think Judge, made a big impact on him.
Yeah, that was such a good point for her to bring it up. Mm-hmm. And that's it. That's the crux of the argument here, because you can have all the prejudicial media. It's right. Just it will not respond the way that the Latah County residents would respond with this weight on their shoulders like that. Yeah,
exactly. They're not, hey, it's no skin off their, I mean, yeah, it's a tragic case. Your heart, sorry to see it and everything else, but it's not no skin off their nose. Nobody up in Ada County is working for the Moscow Police Department. You don't have those problems here. Similarly, given, and then to add compacting it is that it's a small town or it's a small county. This isn't, when Cruz went on trial for in Parkland in Florida, there are millions of residents in Broward County that they could pull for that trial, and he still got a fair trial. He pled guilty. Then at sentencing, the state wanted the DP for him. He unalived more people than Rawling and Bundy combined in Florida. They didn't give him the DP. He's got life. So, so it's just a larger county allows that, because you have some people that say, hey, I'm strong enough. I don't care what my neighbor says. And if they don't agree with me, tough. There are a lot of people that are like that, but here, when you have such a compact area, it's going to be difficult.
Yeah. Did something happen? What happened, American Princess?
Mm-hmm.
Can you still hear me, Kathy?
Yes.
Okay. Oh, I thought maybe I lost connection for a second. Sorry about that. Go ahead.
So anyway, if we go similarly, given the small size of Latah, blah, blah. Okay, the next extensive negative publicity surrounding Kohberger leaves potential jurors to think of Kohberger negatively. Boy, I wonder why that is. Look at all of it. He's an incel. He's this, he's that, he's terrible. He's a loner. No, he's not. You see photographs of him surrounded by women. He's in a Margaret Atwood first row with Handmaid's Tale in his book. Do you know what it would take to get my husband to accompany me to something like that? Never going to happen. He's surrounded by women. Every picture you see of him, he's with women. The woman's trying to save his life here. But he's an incel. Where are you getting that from? Where are you getting he's stalking them? Where are you getting, he wants to see if he can get away with it. He's going to try, he's stupid enough to drive his own car to the crime scene, but he's brilliant enough to know how not to drop or take DNA from him. Which is it? Is he the most brilliant mastermind, or is he an idiot? With all those cameras between Pullman and 1122 King Road, he didn't notice any of them. It doesn't make any sense. And with the keep harking back, Audrey, to the lack of transparency from day one in this case, that just makes it so much difficult to understand Moscow. Why him? Why? We still don't know. Look at all of the headlines with these words, evil, stalker, when individuals hear the name. And you hear it over and over and over and over again associated with him. People are going to start automatically associating the concept with him, because I haven't seen very many headlines that saying Mr. Kohberger is innocent until proven guilty. He's innocent until proven guilty. He is innocent. They have the burden. The burden is extremely high. At this point, he is innocent under the law. He is. And it's not, he doesn't have to prove his innocence. He doesn't have to give an alibi. That's not how things work here. If you don't like it, move to Iraq. That's not how it works here. He doesn't have to prove his innocence. They have to prove him not guilty. And there are reasons that we should be so thankful for that is the legal standard here in the United States.
Yeah, this case is a perfect example of that, because Cassidy Kane, you bring up a great point here. Yeah, why are they hiding their own case? And it occurred to me recently that, yes, we know that Ann Taylor had that motion to compel hearing, and she was demonstrating that Detective Mowry did not save his work. But what I also think that she demonstrated that I don't know if many caught, through the use of Cy Ray and his expertise, is that Brett Payne didn't check his work. He didn't turn over the source materials that Cy Ray would need to look at to see what is going on here. He didn't have enough information to even say, is this what's happening here? And there is an alleged route in that second AT&T warrant. And there is a part of Cy Ray's testimony where he goes through a list of the things that he would need to see in order to just double check his work. Because if you don't double check your work, your whole case could hinge upon something you didn't check. So I just realized that second part, I think, in the last 2 days. So now I'm putting these two ideas together. And I think that Ann Taylor, she beautifully demonstrated Moscow PD, one of the higher ranking officers in that building, they do not save or check their work. And you have the trifecta of possibly Bill Thompson not usually going to trial with these things because he usually pleads out. Was there a sense of comfort there that they may not have to show their work? And I think that it could maybe be supported by the fact MPD in this particular case did not save or check their work. But those are just some ideas that I've been thinking about lately, and that was a great comment. Thank you, Cassidy.
Yeah, it's just that, and that's a valid point, Audrey, because it makes no sense to me why in the affidavit of probable cause, Brett Payne does not tell us the time that friends were summoned to the property. I'm not sitting here. I am not pointing blame. As a matter of fact, my gut, and I'm, again, my opinion is that this had nothing to do with anything. I think that maybe just, they were sleeping, whatever the case may be. But it would have put a stop to a lot of speculation if he would have merely said that they woke up at 11:30. That's when the versus 6:30 a.m., which is what some people have been saying. Details like that. Why has the public never seen? People think that they've seen suspect vehicle 1. The public has never seen an official photo of suspect vehicle 1. They take the Linda Lane footage and they seem to, okay, that's possibly suspect vehicle 1. That's possibly suspect vehicle 1 by the gas station, or that's possibly the red car is possibly really suspect vehicle 1, because we've never seen the photo. We've certainly seen Mr. Kohberger's car. We've never seen suspect vehicle 1. And I don't know why they hid it. I can think of no logical, because it seems to me a lot of the video they had was pretty clear. That one shot that we got from the camera at 11:12, where that pointed right to where that 3-point turn would have been, seems to me that there would have been some very clear imagery. They hid it. So it's sort of like, I don't know why they hid so much. And usually when you get to be my age, we investigate, whatever the case may be. When people hide things, it's never for a good reason. There has to be some transparency here. They didn't have to hide everything about their case. And as a matter of fact, I think a lot of other law enforcement agencies would have released some things, like an artist's rendition of what the suspect looked like, plus his car, to teach these 17-year-olds who are not familiar with the area, away from home for the first time. Be careful. If you see someone who looks like this driving this car, you need to leave. I don't understand why they hid everything. People say, well, the gag order, the non-dissemination order prevented, but there wasn't any non-dissemination order from 11/13 to 12/29/22. They could have released something.
Very true.
And so we see here the impact is greater in Latah because of the saturation of the extensive media coverage on a community that really had to have been terrified from November 13th to the 30th, or whenever the news got out that they had arrested a suspect who they were told is the sole and the correct person. They had to have been terrified in that community, walking around at night, walking to your car. You're trying to go to class, you're working, you've got a baby at home, you need to go get some formula or some milk, and you're afraid to go to your car. That's why it needed to be moved. So then we go on. Finally, given all of this, we hear Judge Wright. Dr. Elia has opined that it was arguably impossible for residents of Latah to be asked to serve as impartial jurors because they are biased against Kohberger, even if they do not want to be biased or think they are biased. This is particularly difficult for the defense to overcome because when humans possess information while experiencing emotion, right, like fear and anger, it is difficult to change the initial opinions that we have formed, even in the face of contradictory evidence. Instead, we as humans pay greater attention to information that backs up our initial preconceived ideas and opinions. I remember when she testified about that.
She was great. Yeah.
I think he really did. I mean, he's quoting her quite a bit here. And then taken together, Dr. Elia stated that in her expert opinion, the best way to ensure Kohberger is tried by a fair and impartial trial is to find jurors who are both physically and psychologically removed from, powerful statement, physically and psychologically removed from Latah. Okay, and then here's number 3, Dr. Brian Edelman, third expert on the stand on the 29th. He's a social psychologist who works as a trial consultant for jury selection and pre-trial research. And in this case, the defense hired him to conduct a survey. Yes, Judge, you know all about that survey.
You're so funny. You're saying it. You can't help but laugh. That made me laugh.
Yeah, he's like, no, here. He's like, okay, we're gonna go past the 22nd and all of the fireworks and everything else, right, Audrey?
Yeah. Yeah.
Ada County residents, Canyon County residents, and Bannock County residents to determine if a change of venue motion was warranted. The key findings, they go into the key findings from the survey. Case recognition is high throughout all of Idaho. Okay, so not surprising. 98% of survey respondents in Latah recognized the case. 93% in Ada did, 90% Canyon did, and 84% in Bannock recognized the case. In Latah, of the 98 respondents that recognized the case, 67% reported they believe he's guilty. How? What evidence have you seen? This is what I ask people. Sometimes, we'll just get into little discussions, and they'll say, oh, he's guilty. Kathy, he's guilty. What are you talking about? And I ask, okay, give me 3 points, 3 pieces of evidence that you have seen, not what you've told, what you think, the secret pile of, this, oh, we only know 2% from the PCA, and then there's 98% that we don't know about. Where's this 98% they can't. So how is it possible that they could already have adjudicated him guilty? I mean, he can't get a fair trial here when you have this many, 67% believe he's guilty. 24.7, hey, don't even have the trial. He's definitely guilty, man. Similarly, Ada County, 68% of recognized believe he's guilty. 20. I thought this was a little problematic when he started, testifying. Like, ooh, boy, oh boy, this is not good if you're trying to argue for Ada. But we learn a little bit later on it's because there's so many other people, you have a larger jury pool that you can pull from. And then he gives the statistics for Canyon and Bannock. And then that takes us to the bottom of page 7, top of 8, Latah County. 51% would have a difficult time convincing them he is not guilty. That should not be. You're supposed to be thinking he's innocent. You're supposed to be thinking he's innocent, and you need Bill Thompson to prove to you that he is guilty beyond a reasonable doubt. That is a high evidentiary standard. It's not civil, where it's preponderance of evidence. It is beyond a reasonable doubt. So here we go. The percentage of respondents who reported Kohberger would have a difficult time convincing them he is not guilty was actually higher in all other counties surveyed. Ooh, that's not good for Ada, for Canyon, and Bannock. But those counties don't have the emotional, attachment. I think that's what they kept driving home. Right, Audrey?
Yeah.
I saw these statistics. I'm like, Dr. Edelman, what? I was expecting to see a lot higher, more of a difference. But, I think he explained it a little bit later. Latah County, 29% of survey respondents reported following the case very closely. 38.5% following the case somewhat closely. In Ada, 58% respondents reported following the case very closely. So here what the judge is doing is he's going to the moving party's evidence. He can't cite to anything. Rebuttal from the state. Now, if the state would have hired an expert who's taking these statistics, Dr. Edelman has admitted that more people in Ada County feel he's guilty. This is from his own mouth, Judge. And then on top of that, then they introduce others, other information, other details. So, but anyway, then they go into some more. You're suffering from stress, anxiety, fear. A higher number of Latah County residents reported talking about the case, and then in Bannock and Ada. So we can just kind of go down a little bit more, Audrey, to this page. Yeah, just finally, okay, meat and potatoes. Let's cut to the chase, Judge. Based on all the information obtained from the surveys, Dr. Edelman opined. That means he gave his opinion. Opined the case recognition and presumption of guilt is and will continue to be high throughout Idaho, given the extensive media coverage the case has generated. In his opinion, population size matters. For example, if roughly 50% of Latah County residents presume Kohberger is guilty, that leaves approximately 15,000 Latah County residents who do not hold this presumption. Of those, not all are eligible to serve as a juror, of course. But in contrast, if 50% of Ada County residents presume Kohberger is guilty, this leaves over 200,000 residents. Much, much better shot of getting a constitutionally guaranteed right to an impartial jury panel. Thus, Ada County has a much larger pool of non-biased potential jurors. That's it. Dr. Edelman convinced him. That's the point. Don't look at the percentages. Look at what those percentages mean in terms of population.
Wow. That's a great way that you just broke that down. Wow.
Even more important, however, Audrey, to Dr. Brian Edelman and his PowerPoints, though, was the issue of personal connections in Latah County and the personal impact this case has had on Latah County residents. The feelings of fear, stress, and anxiety. He's coming right after Dr. Lena. She came in, she drove home this point, and now Edelman, they are on the same wavelength here. They talk about just the emotional impact that this horrendous act that happened right in their community happened. This was also true for the connections to the University of Idaho. That's the elephant in the room. Always has been the University of Idaho and its connections to everything. Local law enforcement. Dr. Edelman testified that these connections and experience are the real issue when it comes to sitting an impartial jury in Latah. Based on the results of his surveys, we see Judge now just summarizing. Edelman opined that his expert opinion there is reasonable likelihood the presumption of guilt prevails in Latah County and that a change of venue is appropriate. Then we see not a lot of time. He's got like a brief paragraph here with DeHeer. I mean, DeHeer, a lot of people after Edelman, they sort of turned off, because, and hey, it had been going on for many hours by that time. They were just tired. but I think she did a bang up job just coming in. She was all business, Audrey. She didn't crack a smile. She didn't, she wasn't there to, she just came in and just gave her truth. Called by the defense to offer her expert opinion as to the validity of the survey work by Dr. Edelman. And she gave quite a few of her credentials, highly credentialed person, university professor. She also does this work on the side. She testified the surveys were conducted in accordance with applicable standards and results. In other words, judge, you can bank on it. There weren't any questions, the way it was put together, there wasn't anything that was a little hokey or sus. That's it. Dr. DeHeer, she basically saying Dr. Edelman is not sus. That's the bottom line. Then we go into the media articles and video clips, and this is where there was yet another bit of drama, Audrey, as you will recall. At the August 29th hearing, this is when Dr. Edelman, during part of his presentation, was going through all of the, the YouTubers and the Facebook groups. And I thought Aunt Taylor was really kind of going on and on and on and on and on. And Judge made a comment, I thought that, and she thought, can we take a break? Then everything was off air for about an hour. We didn't know what was going on. But here we see the court stating that there were also media articles and video clips that provided some of the sensational mainstream media reporting that's been inappropriate, in my humble opinion. And based on information from the court record, there's been extensive coverage that is prejudicial to Kohberger and likely inadmissible at trial. Now we go into what some people say, this is the boring part, because now we go into the legal authority, but this is very important because now you have the judge has to work within a criteria. He just can't say, okay, well, I heard, I liked Dr. Edelman. I didn't like this one. No, he's got to look at what the law says. Because remember, we said already that it is the defense's burden of proof. There is their motion. They have to convince the judge. And here is the legal standard. Per the Idaho Constitution, the U.S. Constitution, a defendant has a right to a fair trial by an impartial jury. To help achieve a constitutionally sound trial, Idaho criminal rule allows for transfer of a case in certain instances, but you have to prove your case to the judge. It's not automatic. It tells you on motion of either party, the court must transfer the proceeding to another county if the court is satisfied that a fair and impartial trial cannot be held in the county where the case is pending. And then he gives further legal authority. Criminal action prosecuted by indictment, which is what happened here, may be removed from the court in which it is pending on the application of a defendant. So very important here. Remember, there was supposed to be a preliminary hearing, Audrey. Mm-hmm. 2023. All right. There was a certain witness who was fighting extradition back to Idaho to be the defense is witness, and that would be 1BF. And she didn't want to come back, so the deal was struck that the defense would go to her and would have an informal tete-a-tete with her, a little conversation. However, we still don't know, because of the secrecy of the case, if that interview happened or not, because the timing is so close. Like, that all happened the end of April, and we know from our revealing of the docket that the grand jury met for exactly 3 days. Friday, May 12th, Monday, May 15th, and Tuesday, May 16th, and they entered the indictment. They signed it on the 16th. So they met for less than 3 days. What do you think about that? Do you think that that was appropriate given the charges?
I think it's too short. I don't know what they were doing.
Maybe goes to the point, again, we're speculating, but under the First Amendment, we're entitled to give our opinion, goes to the point that maybe people trust Mr. Thompson so much that he didn't have to, although we did get the comment from a certain defense attorney that several members of the grand jury wanted to see further evidence. Remember? So saying here, so there we know that once the indictment came down by preliminary hearing, I am of the opinion that the preliminary hearing would have resulted anyway in an indictment, in finding that he needed to be bound over for trial, because the same judge who signed the affidavit of probable cause was presiding over the grand jury. And secondly, a lot of us seem to think, oh, we could have, I think the grand jury, preliminary hearing would have been behind closed doors. I mean, they
Oh,
closed so
interesting.
many hearings. Yeah, they closed. Look at the stuff that they're closing. You know, motion to discovery and this and that. I think that PH would have been, because they're discussing all the evidence that we're not able to see. You know,
That's
still.
a great point. I wouldn't have thought of that. Yes.
Yeah.
Excellent point.
So it's sort of like, you know, the same judge who found not an issue at all didn't say that, hey, Brett, excuse me, Brett Payne. Okay, you are stating to me here, you want me to sign this indictment. You want me to find probable cause here, sir. The timelines are 4 a.m. to 4:25 a.m., right? This is what you're saying, page 7 of the affidavit of probable cause right here. But then you go on to say that suspect vehicle 1 was still in motion at 4:04 a.m. and was seen speeding out of the neighborhood at 4:20 a.m. And you're saying there's only one suspect. How is it possible that Mr. Kohberger could be in the house and driving around suspect vehicle 1 until 4:04 a.m. at least, and then back in suspect vehicle 1 at 4:20, unless it has to be two people? Has to be two people. One person driving, the other person goes in the house, and then, but then that means, but that still means that speeding out of the neighborhood, if he's still in the house at 4:25, how's Kohberger get home? If 5 minutes earlier, the co-conspirator has been seen speeding out of the neighborhood, you know, either. So it's sort of like, if you sign off on that fact, and there's 1,000 other things that we can point out in terms of errors in the PCA, calling the phone the 8458 phone and then calling it the 8548 phone, and all this making up. Okay, I think that we don't have video exactly where SV1 is, but we're just going to, based on my experience here, all 2 years here at the Moscow Police Department as a peace officer, I think that when it was no longer on camera, it exited over here, you know. But in any event, that's why I think that it would have been a closed preliminary hearing anyway, and you know, I think that she would have found it over for trial.
Yeah. Yeah,
But
you're probably right.
But it says here, okay, that if it is by indictment, may be removed from the court in which it's pending on the application of the defendant on the grounds that a fair and impartial trial cannot be had in this county where the indictment is pending. I would have said, 3 days, less than 3 days, you got 5 counts here. You got to count for burglary, felony burglary, and then you have the 4 unaliving counts. You know, you're able to present evidence, even if it wasn't beyond a reasonable doubt, which is what the defense was arguing, even if it was preponderance at that stage, but still you're able to present all of that evidence. I think that goes to show just how much confidence they have in him. That's what I would argue. Not that Aunt Taylor was asking me, but I would have argued that anyway, Audrey.
Oh yeah, it's too quick. It's like, listen to me, give me the answer, and we're gonna keep going. So boom, boom, boom.
Mm-hmm. Okay, now this is where people are missing this point. A motion for change of venue pursuant to Idaho Criminal Rule 21 is left to the discretion of the trial court, meaning he could have very easily, ladies and gentlemen, denied that motion. He could have said, I think that, you know, I appreciate, but look, there's such discrepancy. We don't really know. We can't be guaranteed. It doesn't matter if it's 200,000 or 20,000 people. Let's try and see if we can voir dire all the people out. We'll have a lot of people in. He's got discretion to make that finding. He had discretion to make that finding, and I think that people, you know, need to make credit. I think, you know, he stepped up to the plate and he made a good decision here. Used his discretion. So that brings us to the bottom of 10. Now the next page, Miss Audrey. Then we go into his analysis. Okay, so now what he's doing is he's applying the facts and the evidence that is before him to the law. So now he's saying prejudice. Okay, in deciding a motion for change of venue, the court must determine whether, in the totality of the circumstances, juror exposure to pretrial publicity will result in a trial that is not fundamentally fair. That's the Idaho case that's cited on the first page or the prior page, and it will give you the citation if you want to look it up. The critical inquiry, goes on to say here, is whether the nature of their exposure, whose exposure, the potential jury pool's exposure, about the defendant's guilt, and as a result, they are unable to serve as an unbiased juror. And id means he's citing back to ish. That's what that term means. In determining whether a criminal defendant actually received a fair trial, the Idaho Supreme Court considers the following factors. 1, existence of affidavits indicating prejudice or absence of prejudice in the community where the trial took place, 2, the testimony of the jurors at jury selection regarding whether they had formed an opinion based upon adverse pretrial publicity, 3, whether the defendant challenged for cause any of the jurors finally selected, 4, the nature and content of the pretrial publicity, and 5, the amount of time elapsed between the pretrial publicity and the trial. So the longer that is, it tells us, if it's 10 years before they go to trial, well, that fear and everything and all that is going to fade over time. Some of these factors can only be evaluated during or after jury selection. Ladies and gentlemen, that's where his discretion could have come in very easily, and he could have denied this motion, while others could be evaluated by the trial court in deciding an earlier motion to change that venue. Okay, I don't know if we want to go through all of this. We can kind of, he's going to say no. He says no actual prejudice, okay? So there's 2 points that Ann Taylor argued. Actual prejudice, and then the alternative presumed prejudice, that there was evidence here showing that the members of the Latah County jury pool, they were actually prejudiced. Relevant question is not whether the community remembered the case, but whether the jurors at trial had such fixed opinions that they would not judge impartially in the guilt of the defendant. Stated differently, courts must evaluate whether in the totality of the circumstances, juror exposure to pretrial publicity resulted in a trial that was not fundamentally fair. And then they go on, again, we know this, the defendant bears the burden of proving everything because this is his motion. In reviewing case law, finding of actual jury prejudice, and then he talks about what that means. And you can kind of look up these cases. He cites 2, first Idaho, and then that U.S. Whenever you see 2010 like that, that's a United States Supreme Court case, Stillings versus U.S. That is a Supreme Court case, and that is where you can find it. U.S. That's the reporter. The page 56 U.S. 358. Reporter U.S. page will tell you where, and then you can also look at the Supreme Court reporter. But that is from a 2010 case. Then he turns back. He returns to Idaho law. Testimony of jurors at jury selection, blah, 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 yada, yada, yada. Here, the defense argues the survey work of Dr. Edelman establishes actual prejudice within Latah County. However, actual prejudice cannot be evaluated at this juncture based on a survey on some 400 Latah County residents. State made this point, and so the judge is quoting this, right? 400 Latah County residents who are anonymous did not answer the questions in the court and were not subject to questioning by the state. Okay, good point here. These are people that were anonymously contacted, as Mr. Thompson says, these unsolicited phone calls, they were called, but it's not in court. Hey, we make this argument for the preliminary hearing. The people that were in front of Mr. Thompson in the secret grand jury room, they were not subject to cross-examination by Ann Taylor. What's good for the goose, good for the gander. We have, although it's not Ann Taylor, it's Dr. Edelman on behalf of Ann Taylor, making questioning, but still Thompson did not have the opportunity to cross-examine them. That's what he's saying here, and it's a good point. Without attempting to seat a jury, there is no real evidence such as jurors, screening questionnaires, and testimony. So bottom line, no actual prejudice. We can kind of go on. This is what he found. Presumed that based on the evidence here, we can presume that there is prejudice. Okay, if you want to go to the next page, Audrey 13. You can kind of review this, the law, what our actual prejudice is, and presumed prejudice, what it is, how it's defined, how you're able to show it. And then if we kind of go down a little bit more, Audrey, in cases where juror prejudice has been presumed, the following factors have been examined, and these are the things that the court looks at based on Supreme Court. That's the Skillings case. And then he talks about in Idaho what cases consider. That's the Haddon case. And then when reviewing the nature and content of the pretrial publicity, trial court should be concerned about the actuality or the accuracy, and so on. Okay, and the extent of the articles, and then he kind of goes on. He goes into the factors, and then cites to Mr. Murphy, Dr. Elia Edelman, so all of the defense experts, because there is, again, no state expert. They keep being referred to and cited to, is supporting why there is presumed prejudice. Smaller community makes it more difficult to keep the identity of the jurors private. That was a big, big point, I thought. What do you think, Watch?
Yeah, Well, I think that the jurors could have been unsafe.
Yeah,
And they might not have realized that, even though that there is this feeling towards Brian Kohberger, that could put the jurors in a situation too. So I think pointing that out,
absolutely.
maybe Judge was aware of that. He also needed to protect them, and then this is the best way that the maybe another courthouse can physically protect them better.
Exactly. And what about when I forget which one of the experts brought it up, or if it was, maybe it was Ann Taylor who argued it. Uh, you can try to hide who the jurors are, but people are going to
Right.
see their neighbors leaving at 8:30 in the morning and not coming home until 5 o'clock at night every day. They're going to see that, people are going to bump it or drive past maybe the courthouse and see them, their car parked there, or they're getting out of it, and they're going to put two and two together. It's not going to be too hard to predict and to guess. And then they come back with a non-guilty, and then they got to go back into their communities and live there for the rest of their lives, with people mad at them. How could you have, getting the cold shoulder and everything else? That's hard to do. That's hard to do. Smaller community makes it more difficult to keep the identity of the jurors private. Okay, it was Dr. Olali who brought that point. Testified may hinder some jurors in their decision making, feelings of loyalty to the community. Hey, boy, oh boy, I got to go. My next door neighbor's a cop. All of these factors going on. Lapse of time between coverage and trial, the information provided, and it said it really hasn't been a lot of time. I mean, I want to know who is telling one of the families that this trial should have been in October of last year, less than a year later. I mean, don't they have, and I'm giving my opinion again, don't they have access to victim services, and one of the families have access to a lawyer to tell them, don't expect this trial to be 1 year, even 2 years. DP cases can take 5 years before they come to trial. Can take, longer than that. There was, these mass school unalivings. We just had one last week, and there was some nonsense that that school perpetrator was somehow impacted by Kohberger, which is ridiculous. But there was, mass school unaliving in Texas in 2018 in Santa Fe, Galveston County, still hasn't gone to trial. It's 10 people he unalived and 17 he wounded. We're talking 6 years later because he's in a psychiatric facility. He can't help with the preparation of his defense. So I don't know why they thought that it would come to trial so quickly. So, so it's been a couple of years. The UI killer, people, as time goes on, and this is one of the problems why the state wants to get this to trial as quickly as possible. Memories fade. People can move out of the country, witnesses and things like that. So the greater distance between trial and the event is always going to be just 9 times out of 10 better for the defense than the state, because they have the burden of proof. So he continues to talk on, Audrey, he just continues to talk on the lapse of time and goes on to the top of page 16. And he says this court does not have affidavits demonstrating prejudice in Laptop County. The court must consider the results of the survey Edelman prepared. So here we have Edelman. Boy, oh boy, he's seeing this today. And he's thinking his hourly rate has just gone up significantly, right?
Yeah.
How about Audrey, when he was given all the states, because he was asked by, was it Taylor or Massa who examined, of course it was Taylor, who examined him. Dr. Edelman, could you please tell the states that Idaho, California, Nevada, Florida, Texas. I was like, hey, Dr. Edelman, why don't you just give the states you have not testified in?
Yeah, right.
He was going on forever, but we see that Dr. Edelman had quite the impact on the judge. And again, while the presumption of guilt was similar across all county survey, the number is more impactful in Laptop. Blah, blah, blah. He goes in. He talks about, the percentages from the Edelman survey and the population size of Laptop. If we continue just to go down a little bit more, Audrey, please. So he's continuing to show the impact that Dr. Edelman has had on Judge and considering the undisputed, here's another knock against the state. This is undisputed because there's nobody to dispute it. They didn't have an expert. Considering the undisputed evidence presented by the defense, answered by exactly 0 expert witnesses from, so that's what he's saying here, from the state. The extreme nature of the news coverage in this case, the smaller population in Latah, the defense has met the rather low standard of demonstrating, quote, a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. That's the reason. It wasn't actual prejudice, presumed prejudice. And he is very clear in saying that this is a rather low standard that he needs to meet. He doesn't have to jump very high to meet that standard. And he talks about convenience, interest of justice. And in this section, Audrey, if you want to kind of just, skim it down to the next page, he goes into the staff and security, that there's only limited staff at the courthouse. Yes, they can pull in sheriffs from Latah County, but they're understaffed. The Moscow Police Department's also understaffed. ISP is also understaffed. And quite frankly, the last 2, ISP and MPD, are going to be called for, to give trial testimony here. Then he goes into, if you go down a little bit more, 3-month trial. Yeah, wishful thinking, everybody. This trial's going to go much more than 3 months. And no matter where it's at, you figure a couple of weeks, they could be in voir dire for a couple of weeks going through, because of all the even if it's up in Ada County, because of Ada County, they like you said, almost everybody in the state of Idaho has heard about this case. And then they go into, and you see how thorough Ann Taylor is. You think anybody's getting off that stand after 2 questions? No.
Oh.
No, I mean,
I think she's been nice so far. We haven't seen her other than nice.
I wanted to ask you this, because I was reading this order today. I thought of you. I said, who do you think? Okay, so they're going to do voir dire. They seat their jury. They have their alternates. And then Thompson has to get up and give his opening statement. This is where he's going to give the evidence will show, ladies and gentlemen. The evidence will show. The evidence will show. He'll give his summation of what the presentation of the evidence, and then you're going to get Ann Taylor coming up, and she's going to say, no, Brian Kohberger is, you have to find him not guilty, and this is what the legal standard is, and here's why, blah, 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 blah. And then, okay, call your first witness, Mr. Thompson. Who do you predict at this point? I know it's a very difficult question, because all the evidence has been, for the most part, withheld from the public. Do you have any idea of who you think? Because I have 2.
Out of like experts, or
just the first person he's going to call, the first person that you anticipate, Bill Thompson, whether this trial's in Ada County, whether it's wherever, it's a Bannock County, who do you think is going to be the first? I have 2. I say the logical people, because we had debates about this for the preliminary hearing. Who would be the logical first person to call? It's either you go chronologically, would be maybe the police sergeant who's at the new building, and when the 911 call comes in, and he then then with the 2 officers, they report, and then start with him about what they saw. Or alternatively, I would predict that it could be Mr. Brett Payne, or Detective Brett Payne, because he wrote the affidavit of probable cause. So he could be the first witness. But whoever it is, we're going to start from the first witness on. Ann Taylor's going to, whoever, whether it's Mossop or Taylor, or whoever it is, they're going to be there for a while. I mean, because she is so thorough. She's going to go through things with a fine tooth, and then you have, then the prosecution's going to redirect, try to clear up any messes that Ann Taylor is able to, establish to show why there's problems with the case. 3 months, not happening. I say I would project it at least by 2. I say at least a 6-month trial. What do you think, Audrey? You think it's possible they could do it in 3?
I don't think so. I think you're right. It's definitely going to go over.
Yeah. I mean, OJ, I think that they projected it would be a 3-month trial, and it actually went 9. It went to 9. But anyway, that's going on, and it says, so Latah doesn't have the court clerks, and and then people within, just the people that do the main. There's just not enough staff, and the building is small. Parking is a problem. Parking in the street. Then you have, of course, the high school that's right next door. That was an issue. You got kids who are going to be going back to school. Let's just say the trial date doesn't change. Possibility the trial date could change, because how do we know that whatever courthouse is going to have availability, June 2nd times 3 months. You know, they have to find a place, whatever it is, whatever the new county is, that could accommodate, or guess what? Trial date's going to get bumped. Okay, so we can prepare for that, you know, before anyone else, you know, says, oh, defense is delaying again. Hey, you know, if here's my response. I'm gonna hit the, you know, repeat button, just like kind of, hey, if the state of Idaho would have not opposed the motion for change of venue back in February, all of this could have been handled. There would have been no problem about anything. They could have found the new courthouse. Trial date could have started June 2nd. Okay, so then we go into court staff. They're trying to do, okay, reality is they don't have enough individuals to perform it. They just are understaffed for something like this. Yes, for their normal thing. And then he goes into the fact that there's only 2 judges there. It's Megan Marshall and it's Judge, district court, and the, you know, and then the magistrate. And so if Judge is tied up here for this long, what about all the other cases that they have, you know, all the you know, the 17-year-old or the 18-year-olds running across Band Field that get stopped and have to be prosecuted. These, you know, these very big dangers to society. You know, these other cases that, you know, the door knock, you know. Hey, just imagine if the Moscow Police Department would write reports every once in a while, how busy they would be then, right? Okay. That's my opinion. Just giving my opinion on the Okay, so then we kind of go on and kind of go on to the next page. Yeah, you could be a lot more busy than you think you are, Judge, right? Idaho County Courthouse, significant issues for the trial of this length. Courthouse lacks the space, and so forth. Few options available. Meeting room for the even for jury deliberations, there's a problem. Fitting 12 to 13 jurors in the small jury room, you just imagine, would be crowded. Fitting 18 in there, they would start getting on each other's nerves by like day 3. You know, having to be in that small tiny.
Oh, jeez. Yeah.
The issue of continuing day-to-day operations, these are the other things. And then, you know, security would be tasked with trying to bring the jury into the courthouse in a fashion that ensured their safety and privacy, while also ensuring the court's privacy. Only options. And then he just he really spells it out, why it is that this thing needs to move. Issue of continuing day-to-day operations in Latah County Courthouse. Magistrate judge continue to have yearly hearings. Clerk's office strained by the resources. Traveling to another county for 3 months is indeed inconvenient. Okay, he's saying here, yes, it might be inconvenient. It's the lesser of 2 evils, Audrey. This is what basically he's saying. If you want to kind of scroll down to the next paragraph. And okay, now there has already been misinformation, as we've been talking about, Audrey, right? We knew this was going to happen, right? You knew that they, whatever way this order came out, the misinformation, and the misinformation has already started to hit the airwaves from multiple sources, that Judge has recused himself. He's no longer the judge. This is ridiculous. It is absurd. He has made no such ruling. If he entered an order of recusal, or if he entered an order of disqualification, removing himself from the case, that would be one thing. What he's saying here, let's read, because we don't deal with fairy tales, we deal with facts, right? Kohberger's motion to change venue is granted pursuant to, and he gives the legal authority. The court orders a transfer of venue without specifying the new place of venue. Now that's interesting. Usually they will say in there, we order a change of venue to blank county. He's not doing that here. And refers, quote, this case to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another. So he's not making this decision. He's saying, okay, it needs to move. Supreme Court, you tell us where it's moving to. That's just basically what he's saying here. If you can go down just a little bit more. So he's saying here, and refers the case to the administrative director of the courts for assignment by the Supreme Court. So he can't call up the Supreme Court and says, oh, I'm sending you an email. No, it's the proper procedure is, and you'll see on the distribution list, it's going to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another judicial district, and assignment of a specific judge to preside in the criminal proceeding. Not pretrial, trial. Okay, this was always going to be about trial. Is it possible that the Idaho Supreme Court could say, given, okay, Ada County and all the things that the judge is saying here, it's just possibly they could reassign right away. But I don't see, if you look, he's still the jurist. There's things coming up real quick. And another misinformation by people that should know better, is that Ann Taylor, is admitting guilt or doing something by all of the recent motions that she filed. If you look at, there is right there on the June 27th trial order, which people obviously have not read. It said there that the motion, page one of the first things on their motion challenging DP, the deadline was September 5th, 2024. That's why you saw those filings the other day. That was a court-ordered deadline. And now the response. So now expect a response from the state of Idaho coming back and saying why DP is appropriate. That is due the 10th of October. And then finally, a reply. Remember, we said motion, response, reply. The reply from the defense is due the 24th of October. And there's a hearing coming up before Judge John Judge on 11/7/24, November 7th at 10 o'clock a.m. That's the hearing on whether or not the DP should be kicked. So he's got, and then there might be things coming up. You may come tomorrow and see something that somebody wants a hearing set for something or other. June 2nd is still the trial date right now. That's not a lot of time for a case like this. So there may be other things. He is the jurist right now until or unless he either recuses himself or removes himself, or the Supreme Court. And I just don't see the Supreme Court removing him. I don't. Possibly. What do you think, Audrey? Do you think that this order says that he removed himself, or he's not going to be the judge? I don't see where it says that.
Right. I don't see where it says that, because it sounds like he's saying, I'm going to assign both of these things to the Supreme Court and they'll let me know.
Right. If I need to now travel to Ada County or wherever it's going to be, or if it's better to have a jurist up and wherever. But for pretrial, there's still other things that are on that. People should read the trial order to become more familiar. There's stuff that's coming due and that is due, and there are hearings that are set. He's still the judge until he either removes himself or the Supreme Court says you're removed. And I can't see the Supreme Court. Then that would be, wow, Judge is incompetent. The Supreme Court saying Judge is incompetent. He can't do pretrial. They're not moving Kohberger. Kohberger is staying right where he's at until trial. Then the new county, then he gets moved. And then depending on if it's 20 miles away, I don't know if he would be staying, or if they would transport him every day, or if he would stay at the new, jail in whatever county it is. Obviously, if it's Ada, I can't see them driving him back and forth every day. He's going to have to move, which might not be a bad thing in the event that the former police chief wins this election.
Right.
Because if he becomes sheriff of Latah County, guess who? He's the innkeeper for Mr. Kohberger. So just in time. But anyway, so if you go to the next page, the final page, this is what we call the distribution list. This is where you will see copies of this order. I certify that copies of the order granting defendant's motion to change venue were delivered by email to all the people: William Thompson, Jeffrey Nye, Ingrid Beatty, Ann Taylor, Jay Logston. So these are the defense and the state, Eliza Mossoff. And then finally, Sarah Umsman, administrative director of Idaho courts. Not going to the Supreme Court, it's going to her. And then she will do whatever procedure they have to get that before the Supreme Court to answer Judge Judge's question, where should this trial be? And then they start with, can it be on June 2nd? Don't be surprised if it gets moved.
Right.
Okay, I think that brings us to the conclusion of our journey through the motion for change of venue, January of this year, ending with this order that came out late Friday, but which the public only got to see today. Any questions or anything, Audrey, you want to add, or anything we need to cover?
I loved how you broke that down, and as you were breaking it down, you gave us little hints about what little things mean as we're going down. I've never experience something like that. And so that's amazing that I get to take these new skills into the next time I read one of these on my own. Wow. Thank you.
That's what I want to do.
It's amazing.
That's what I try to do, at least, for most of, with the podcast, we're going, like today. Okay. Today's podcast episode, big surprise, it was the state's response to the 17th motion, of the 17th discovery response. Everything was under seal. And then we'll talk about what does under seal mean? What's a motion mean? What's this with that? So that way people, if you don't read these documents a lot, kind of help them. Because I think that right now, especially with more and more people are becoming interested in the case, I really appreciate you dropping the link. I would really love it if people would subscribe, because the more subscribers we have, the more the podcast gets out there, and we are global. I have people from Japan that write to me that like the podcast. But if you go to I know a couple of them have a search engine. So if all you want to do is research, okay, I want to do some research on IgG. All right. You plug that in, it will take you to the description for all of the items so that you don't have to go through this long docket, and then you can kind of get some, okay, look at this, look at that, look at the other thing. Thank you very much. Read the document. So I think we're going to have you're going to start seeing a lot of stuff hitting the fan right now. This is done now. We got the state responding to the DP and whatever. We got the IgG. They're trying to get Cy-Ray knocked. They're trying to say, his alibi defense is insufficient. There's a lot of stuff that still needs to be decided. The motions to compel, Fourth Amendment I predict motions to dismiss are going to be filed. So we want to become aware of what came before to explain it and give people knowledge. And yeah, I'd love it if people would sub to the YouTube channel so we can kind of get word out about the facts, not the fiction.
Yeah. So everybody, all of Kathy's links are in the description. Her Spotify's there, her YouTube is there, Amazon, Apple, and there's a few others. And this is more than a podcast. So Kathy's InDieZone podcast, it is more of a resource. She beautifully breaks down these documents just like we did right now, but they're in 3 to 5 minute segments.
Everything's under 5. Some of them are 3.5 minutes. I try. People are too busy. They don't want to hear me talk. I just want to kind of, okay, meat and potatoes, as Harsh would say. This is what you hear. This is where you can go. Look at this page. This is what this means. So that, people, they don't have time to go through that. That docket is so difficult to go through. It used to be a time where there were just a few things, especially with all the things that are hidden, but just imagine if they start releasing how long this docket's going to be. So yeah, this is just 3.5, 5 minutes. Not one video, not one podcast is 5 minutes, more than 5, like 5:01.
It is so easy to listen to. I have someone while I don't know, they're just on in the background, and I find myself stopping what I'm actually doing, because I'm listening for the way you break it down, and then I'm on to the next one. It's so easy to listen to, and you have a great voice, and you're so knowledgeable about the law too. So there's more than just the reading, all of the knowledge that we received today from you too. So I would recommend everybody check it out.
Thank you. Yeah, it's sort of like a couple of people have said it reads it kind of goes like an audio book. We started episode 1 is page 1 of the affidavit of probable cause. Page 2 is we're literally filing the docket. So yeah, Audrey, I appreciate it. I always enjoy chatting with you, whether it is, on X, Twitter, on the phone, whatever it is. I really appreciate it very, very much. And I want to thank you. I really enjoyed the comments and the questions that you got from your readers, and congratulations on the channel. Keep up the great work. And I'm sure the next time we speak, you probably have 500 or 1,000 followers.
I hope so.
Do a great job with the DNA stuff. I go to you sometimes. I need some breakdowns of what the DNA stuff means. So yeah, definitely keep up the great work.
Yes, I'm always looking out for the things that you post on X and on YouTube. And I'm always asking Kathy questions, and I will I will reshare her things, so you'll see it from me too. And a great resource, Kathy is. Thank you so much for coming on today. I can't wait for us to schedule this again.
We will definitely do that, Audrey. Listen, have a great evening and a good night to everybody. Good morning, whatever time of day it is, wherever you are, and appreciate you. Thanks a lot.
Thank you. Bye, everybody. Bye, Kathy.
Bye.